We sitting up in here watching. Let me play it for y'all. This live right now. Young Thug and Gunna's preliminary hearings of some sort. Y'all can see for yourself how these people is playing with their life. You know what I'm saying? Your life is getting played with right now. This is how this court stuff go, man. This shit is scary. I don't care what nobody say. I done been through it quite a few times, and I know. And just when you think that a motherfucker won't tell on you, they tell. And don't try to put it on me. That's a trial transcript. I showed y'all my paperwork a couple days ago. I ain't got I didn't tell. So don't put it on me. But get what? Somebody gonna tell in this case. Y'all can believe that, man. You can believe it's gonna be a whole lot of telling. So we just gonna let the recording play, man. This is live in Atlanta, Fulton County Courthouse in downtown Atlanta. And they are trying to locate Gunna. I think they said he's been transferred, but Young Thug is sitting in the courtroom, so eventually they're gonna start talking to him. Let's get it. I know the camera looks small, the TV looks small, but it's actually 86 inches. That's 86 inches, y'all. So I don't know how it's playing to y'all.
Is Livingston, Madam?
Just got it, so we ain't hooked the surround sound up yet.
What do we do to locate Mr. Kitchens? Apparently, as you mentioned, he's been outsourced, but what do we need to do in order to locate him for another hearing? Because we probably can't do that this morning, can we? Well, first, can we locate him for this morning?
He's on loan out, Judge. I think that would have to be something done by Mr. Chamberlain or Ms. Imana to have that county to put him on Zoom like the other counties did.
Okay, but we thought he was in Fulton County Jail, so we didn't know he was outsourced.
No, he's not outsourced. He's actually loaned out to another county. He's loaned out to...
They don't have that location in
yeah, see, that's not, we don't have that. Madam?
I'm so sorry.
I have the county, Judge. Should I say it over the Zoom?
Henry County, I believe, Your Honor. He was
The man got a court date and they flip-flopping him around. They don't know where he at. This is Gunna. They talking about Gunna. The man they don't know where he at. They trying to figure out where he's at. And he has a court date. Y'all know where he at. You know he had a court date this morning. Why the hell do y'all not have the man in front of the camera at court? Now they trying to locate him. This is one of the little small games that they play with your life.
Mr. Saint, hold tight. I'll let you complete your thought in just a minute.
So he's in,
This is on Mr. Kitchen stuff.
Yeah, just give me a second. I'm talking to Mr. Chamberlain right quick, and I'll let you complete your thought.
he's in Henry County. So he's in Henry County since May. He's been at the Fulton County Jail on August 18th, because that was the last hearing date. Now, if they chose to move him, that should be an item on the booking stage.
What did that? This is fair. Okay, Mr. Sadon? Yes, sir.
Yes, Your Honor. Mr. Kitchens has been in Henry County nonstop since a few days after his voluntary surrender. We do not want to postpone the hearing today on the state's motion to restrict discovery. If the court will permit us, we will waive Mr. Kitchens' presence for purposes of this hearing, and we can proceed. We're ready to go.
So I will afford you the opportunity to, if you wish for me to reset it, I have a date certain on October the, Mr. Chamberlain, what day did we give for the? What was the date for the other folks? Not the 5th, 18th?
No, it's the fact.
I can give you the 13th of October, sir, and we can have him produce. But if you want to go ahead and waive his presence for the purposes of this motion, I certainly, that's within your wise discretion to do so.
Well, Your Honor, given that opportunity, we waive his presence and will proceed as the court directs today.
Okay, and just on the state's motion to restrict discovery, is that correct?
If the court is also going to hear the severance motion, although I don't know if it's actually on for purposes of a hearing, we will waive the severance motion as well. I think the only thing that we were noticed on is the motion to restrict discovery.
Yeah, I think that for your client, that is correct. That is correct. So I would need to set the other one over for it to be heard. The motion is set.
That'll be fine. That'll be fine. We'll do the restrict discovery today as the court directs.
Okay. All right. So, Mr. Geary and Ms. Rosenwasser, I think that Mr. Kitchens is going to waive Mr. Sadon is going to waive his presence just for the limited purpose of for the motion to restrict discovery, and that Mr. Williams is in fact on the platform. So, all right, now. And I mentioned earlier, if you had a chance to talk with counsel in regards to what arrangements could be made in terms of pursuant to 17-16-4D, but and I did read your pleas, but I believe that the statute does give me some flexibility in terms of what can be fashioned. So I was wondering if you had an opportunity to talk with your colleagues across the way to fashion something such as letting them physically come and inspect any evidence or discovery, as well as binding them to as officers of the court and subject to discipline, not disclosing location of witnesses or third parties.
So, Your Honor, first to start, it's been our position in this case to be a little more conservative about the out-of-court conversations we're having with counsel, just due to the numbers and the nature of the case. However, I have read through, for instance, the motion that was filed by Mr. Sadon. I think that we are actually fairly close, and the parties and I are in agreement in certain things. So first, I want to tell the court exactly what we are asking for in total between our motions.
Okay.
We would ask that the home addresses of our witnesses not be disclosed to anyone. We would ask, and should counsel have difficulty locating a witness, they can reach out to us, but we do not want a witness list with those addresses published. So that's our first request. Our second request is that the information on any proffers and statements of cooperating gang members be restricted until 30 days prior to trial. I will note for the record that at this time, all of our cooperating or gang associate statements, any statements made by someone who is one should further individuals, defendants, or other associated gang members come forward, we would like the option to restrict that information on the proffers and statements until 30 days before trial. Our third request would be that this court order defense counsel, as officers of the court, not to disclose the current locations, dates of birth, or contact numbers of any witnesses with their defendants or defendants' family members. So while they may have that information so that they can contact them, and again, we do not want the addresses disclosed, but email address, phone number, that sort of thing, we would ask that be absolutely restricted from being disclosed to defendants in this case or their family members. We would also, our fourth request would be that this court order defense counsel to avoid sharing discovery materials with non-members of the discovery team. So if they're not of the defense team, I'm sorry, Your Honor. So if they are not a member of the defense team, we would ask that discovery not be allowed to be shared with anyone outside of the members of the legal team. We would then ask, our fifth request would be a request to restrict all parties, obviously that includes the state, all of us, from sharing discovery materials publicly. So I want to be specific about this. As we noted in one of our filings, a picture from the discovery, like someone took a photograph of a document out of discovery that named an individual that provided information to police. That document was shared publicly online. You can find it on Instagram, Reddit, YouTube. It's all over the internet. We want that not to happen again, and we're concerned that it happens. So we really want that restriction from anyone publicly sharing any discovery materials with news media, etc. And finally, we would ask for an order preventing the disclosure of any state's witnesses within the Georgia prison and jail system to anyone outside of the prosecution team without prior authorization from this court. I do want to, so those are our requests. Yes, and that was what was filed in our August 24th motion to limit disclosure of witness location. We would ask that any witnesses that are current state's witnesses that are in the jail or prison system, that this court order that those locations not be disclosed without prior authorization for this court. We're specifically thinking about the type of request that could be made to various prison systems or jails. And so we would ask that if the defense team would like those locations to first receive prior authorization from this court. So those are our requests in full, Your Honor.
Yes, 6. Thank you.
Yes.
Let me see if I can recap them again. One is to not disclose the home address or publish home address of any witnesses or parties. 2, that information on proffers of cooperating witnesses to include gang members, no disclosure until 30 days prior. And you represent, as well as you've given statements that you have thus far as part of your discovery, correct?
Yes, but
you want to reserve, you want to have the option, should other people make proffers, to not disclose those until 30 days prior. Is that correct?
Yes, Your Honor.
Okay, all right. Number 3 is you want to order defense counsel not to share locations, date of birth with the defendants or the defendants' families.
Date of birth or any contact information.
Or contact location.
Information, phone numbers, etc.
Okay, phone, email, all right, okay. Number 4 is not to share any discovery with members outside of the defense team.
Yes, Your Honor.
Okay. Number 5 would be to restrict all parties from sharing any discovery with any outside news, media, or any other on any other social media outlets, correct?
Yes, Your Honor.
All right. Number 6 would be to not disclose the location of any witnesses in any DOC or custodial locations without prior disclosure from the court. Is that right?
Yes, Your Honor.
All right. Okay. All right. All right. So those seem to be the 6 things you want me to to inquire about. Okay.
Yes.
Okay. Mr. Garland, I should say, or Mr. Samuels, I should say.
I think Mr. Sada is going to address it.
All right, Mr. Sada, sir, in regards to any of the six, do you wish to have argument or have the court weigh in on any of those?
Yes, Your Honor. I'll go ahead and say that. Primarily, I'd like to focus on number 2.
That's information on parties or cooperating witnesses, and not to disclose any additional proffers that may be made until 30 days prior to trial.
That's correct, Your Honor.
Okay.
We believe that waiting until 30 days before trial for any, unfurnished or non-produced proffers of cooperating witnesses and gang members doesn't give us enough time for investigation. We have outlined in our own response a better system for disclosure of such information. And I can get very specific on this. I've taken the time, and I know that the rest of the kitchen's defense team has taken the time to actually go through the 3 disclosures, discovery disclosures made by the state. Insofar as cooperating witnesses, so to speak, there is one person that has said anything at all about Mr. Kitchens, and it was exculpatory. So we don't have anything that suggests...
There's Young Thug in the upper left-hand corner.
That has proper anything incriminatory. To now have to wait until 30 days to see if that changes before trial, it doesn't work. We're officers of the court. There's absolutely no reason why that information cannot be disclosed on a timely basis. The first disclosure we have set forth would be sometime in September, with updates every 14 days. Obviously, the court can play with the time periods. But if we're not going to be disclosing any of the information pursuant to numbers 1, 3, 4, 5, and 6, there's no reason why the defense counsel can't have the proffers and the information regarding cooperating so-called gang members. As I said, we're officers of the court. We understand what the rules are. We're subject to discipline. We're subject to contempt. We'll sign off on whatever is necessary to protect the state's interest and obviously the interests of the public and ourselves. There's just no reason to wait. Waiting is going to make it more difficult for this court to go to trial when it now deems it appropriate, which I think is January the 9th, because you'll be getting this information 30 days before January the 9th, which puts us into the holiday season. I believe that fairness here dictates that it be disclosed much earlier under the scheme that we've set out in our response. As I make reference to 1, 3, 4, 5, and 6, all those things are fine. Defense counsel, I dare say I speak for everyone. What we need is what supposed witnesses are saying about our clients. That's the key to our preparation. So if you'll be willing to look at our response to state's request number 3 in what we filed, I think you'll see exactly how we would suggest that the court can handle this.
I'm taking a look at that right now, sir.
No, this is live right now. This is right now. This is going on currently in the Fulton County Courthouse, downtown Atlanta. Young Thug.
I mean, I think that the court's concern is
Gunner is not in court. His defense counsel has waived. What's going on with him? Damn, we lost it. Let's get back into it. Did we lose it? We tripping. There you go, y'all. I'm back on, y'all. This is live, by the way, y'all. This is live. If we can get back into it some type of way. Yeah, but this live. This is current. This is right. Uh-oh, damn, got out of there again. All right, here we go. This is live.
But particularly what has concerned us and what has spurred some of these motions is the fact that a page with the name of a person and Mr. Kitchens, whether or not he was implicated, this person made statements against defendants in this case. This person was named, and this information was posted online, and the court even searches. If you go on Instagram and search, snitch YSL, this discovery document that we served only on the Dropbox to defense counsel in this case. This page appears on Instagram, Reddit. I found it on TikTok. It is everywhere. There's a YouTube video with like over 5,000 views. We are so concerned because this danger has already existed. So that's why we're raising this today. At the end of the day, all of this is in the court's discretion, of course, but we're going to stick with our 6 asks that we made at the beginning of this hearing. And obviously, this is all under the court's discretion under 1716-4D. And again, we will provide witness lists, but we just don't want to do so with the addresses, and we do want it subject to the restrictions that we've asked for today.
Mr. Sadow and Mr. Adams or Mr. Steele, do you have any thought? Do you have any discussion, or is it your concern about number 2 as well, and number 3 as well?
I'm sorry, Your Honor. This is Steve Sadow again. I'm not sure I understood the court's question.
Number 3 is okay. You are actually it states request number 3 is wholly restrict the information on proffers of statements covering gang members till 30 days prior to trial. So the other of the state's requests, do you have any objection to those, sir?
All right. Just to make sure that we're on the same page. Our response to number 3 matched their motion.
Yes, and that's
yes. Right, and today it's now number 2. So we spoke.
Oh, don't tell me what in the world is going on? Tighten up, 11 Alive. Yeah, this is live, man. If you just not tapping in, man, this is a preliminary hearing for.
Just to make sure that we're on the same page.
This is a preliminary hearing for the YSL crew, man. So they down to Gunner and it looked like they broadcast have died. But anyway, man, they down to Gunner and Young Thug. Young Thug is in the courtroom via camera. Gunner is not. This is some of the game. Let me tell y'all something, man. Now you ain't got to believe it for you ain't got to take my word for it. But when I tell you that court shit is so fucking scary, bro. That court shit is scary. I done been through that shit. That's my trial transcript. That's the trial transcript. 16 years behind them 1,000 pages. I call it 16 years. And as you seen in my post a couple days ago, I took my ride by myself. I didn't take my Cody, rest in peace, because he's now deceased, because he never did let go of the crime life. You know what I'm saying? But rest in peace to him. But I took my ride by myself. You see these motherfuckers here, man? Boy, they gonna go to telling left and right, man. Y'all better pay attention. This court shit will scare the dog shit out of you. Tap in, man. Anybody that done been to trial, anybody that know what I'm talking about. You see that? I can't show you the names and all that. I can't show you all that. But it's a book. Tap in if you done been to trial and you know what I'm talking about.
And the person says, I don't remember being there. Can you show me something? And I would like the permission to have the discretion to use it in that way. So that's what I'd like you to consider. There may be times that that has to happen. It happens all the time, actually.
Yes, as long as it's you or somebody from the defense team is doing that, I don't see an issue as to that.
Okay.
Monster.
Your Honor, we would ask that if he is going to do that, again, we understand, obviously, that's part of the process, but we would.
Yeah,
ask
Lions
that-
True, bro. I'm trying to tell them Lions True. That what my channel is mostly about. Like I'm with helping the convicted felon, you know what I'm saying? Cause I was in that bitch from 98 to 2014 on the AR. You know what I'm saying? I did so good when I came out. I got a full pardon from the state of Georgia. You know what I'm saying? All rights are restored. I'm trying to point folks in that direction, but I'm also trying to let these young cats see that, hey, man, these folks trying to take your life, okay? And 10 years is a long time, but these folks gone for 25 to life. We talking about 10. Can you just put yourself in and imagine 2032? Can anybody think that for 2032, you got to deal with being in prison from today, let's just say today, to all the way to 2032, bro? That's a long time, bro. That is a long time. That means if you're going in at 27, you coming out at 37. You missing out on the best years of your life. I went in that bitch from a couple of weeks before I turned 23, and they kept me in that motherfucker until a couple of weeks after I turned, a couple of weeks before I turned 39, bro. I missed a whole lot. I missed a whole lot. I missed a whole lot. Y'all don't want this, man. If you've been getting away with these crimes, you're not gonna keep getting away with it. Go head on and cash out and get out the way. Because I'm telling you, these folks is trying to take your life. They trying to take you off the street. Let's tap in.
Trying to go interview people who are in the state prison system or the federal prison system. They'll speak with us, but I assume that has nothing to do. I just don't really comprehend it. But as long as we're
Just as long as you, I think what the state has to do is you have prior disclosure from prior coordination or permission from the court. So if you say, look, I'm going down to see such, that's fine. I mean, I'm going to give it to you anyways. But I think that they're just asking for me to bless off on that, because then that kind of creates a kind of a paper trail or something.
And see, here's the thing, bro. Here's the thing. What you don't understand. Those judges and DAs and lawyers and court-appointed lawyers and everything, they go to school together. They're friends. They're buddies. Some of them fucking each other. You don't think they'll trade one life for one life? You don't think that they'll trade one for one? I give you this motherfucker here. He's a drug dealer. He committing terror on the street. I give you him. If you let my client, that's a fucking aggravated child molester, let him go. I'ma give you this thug off the street if you let this child molester go. They play games with your life. You know what I'm saying? But guess what? If you don't give them that power to play the game with your life, they got nothing to play with. These folks is playing chess while you out here in these streets playing checkers. Believe it.
information, like as soon as the state has it, they have an obligation to get it to us.
I believe that Mr. Sadow has suggested that I tailor that particular restriction to.
Yeah. Lions True. Yeah, man. These folk playing games, man. These folk play games with your life, bro. I'm telling you, I done sat through it. I done been through it too many times, and that's why I be trying to tell motherfuckers, look, hey, I'm done. You understand? They got it. They beat me. They made me tap out. I messed around and caught my time. Let me get out of here. I messed around and caught my time. And once I came out, boy, well, look, I was in a Clayton. Damn, I keep messing up, y'all. I was in the I got out from the Clayton County Transitional Center January 16th, 2014. And boy, when I tell you I walked out that door and I ain't never looked back, man. I ain't never looked back. Look, I done got a trucking business, lost it all. I done been through a divorce. You know what I'm saying? I done been towed down in all kind of way, but guess what? Going back to the street life, I can't do it. I can't goddamn do it. Never, never in a million years. I got a great support system now, and I'm not gonna let that support system down. You got a lot of people looking up to me, and I'm not finna let nobody down. I can't do it. I can't let my kids down. I can't let myself down. You know what I'm saying? The state of Georgia believed in me enough to give me a full pardon from my felony conviction. So my past don't even mean nothing no more. You know what I'm saying? So I can't let none of that down. I can't. I just can't.
Of witnesses in the Georgia Department of Corrections or any custodial locations without prior approval from the court. So I think that we've, you know, if you wish.
Damn, I gotta put some surround sound on this 86-inch, man.
For the court's signature, I'll consider it at that point, okay?
So, Jay,
Yes.
Jay, I'm unclear as to whether this, I mean, I think the state's motion applied to all of
It
it.
would apply to everyone, yes.
So I don't know if the court wants to hear from other defendants.
If you have any specific objections to it, Mr. Knapp.
I mean, I have a response to the motion.
Yeah, okay, since you have a response, do you have any specific objections or additions that you like for me to consider?
Well, I'm not sure I'm clear that I understand the court's ruling because I haven't seen the paragraph that Your Honor was referring to. However, just for the record, on behalf of Mr. Kendrick, I have, and I'm going to go by the 6 points that the state used today as opposed to the points that they highlighted in their motion. I have no objection and consent to numbers 1, numbers 3, numbers 5, and number 6. With respect to numbers 2 and 4.
Could you enumerate those for purposes of, so the court can just make sure I understand?
Sure. The state's point on I'll refer to it as home addresses, which was their first point, not to disclose home addresses. Well, Mr. Kendrick will consent to that. Their third point on defense.
And see what a lot of people don't realize, man, how them folks be shoo-shooing, whispering. It's little motions. You know what I'm saying? It's little motions, it's little gestures and stuff that be flying across the courtroom. And guess what? You as a regular person will not get what is going on. You will not see it. These folks playing with your life deeper than the words that they say in court. It's way deeper than you just hearing what they said. And I'm telling you, they come out with so many terminologies that your head will spin. I'm telling you, you'll be sitting, it'll happen to you. You'll get 30 or 40 years so fast, you'll be sitting in your cell 10 years down the road trying to figure out how it happened. It's a lot going on in this picture right now. And guess what? You can turn your life around and don't go in that direction. Everything is all good. Some of y'all might be catching a real wave, you know what I'm saying? Because folks, you know, a criminal catch stuff in waves, you know what I'm saying? You catch a good wave and you ride that wave. Cool, boom, you fall off. You lose whatever. Boom, you catch another wave, you get it back up better than before. But guess what? When that time comes, when them folks want your head, because they'll let you run that wave for a good 2, 3, 4 years. The feds are watching for years, man, and build all kind of stuff on you that you forgot about. I'm trying to tell you, man, this they playing chess with your life.
Materials, we would need to do that on a very limited basis, but we would not provide a copy of any of those materials to anyone, electronically or otherwise, if we're questioning a witness or interviewing a witness in the case. And then, of course, number two, I have
Number two
being the statements being turned over 30 days or less prior to trial. That would, I think, effectively make me ineffective.
I'll save your argument on that. I'm gonna modify it. Okay.
Thank you, Your Honor.
Do you have any other specific objection?
Not to that motion by the state.
All right. Any other councils who are present today want to be heard on the issue of the motion to restrict discovery? Yes.
Can I just, you asked before, and then I didn't want to interrupt. On the paragraph that you read aloud, Your Honor, it's on Mr. Kitchen's page 3 in the center, I believe is where you were reading from.
Yes.
Yeah, man, they trying to ruin your life, man. You think them folks for 1 second ain't been watching Young Thug? You think that they don't know about the rise? You know what I'm saying? He's shining on TV with $2 or $3 million worth of jewelry on and just doing what he want to do, doing what he want to do, going where he want to go. You know what I'm saying? He got all his little minions under there saying what he want them to say and everything. They've been on the TV and on YouTube flashing guns, rolling weed, just doing all kind of stuff. You think for 1 second that them white folks not looking at you? Yeah, you shining for the hood. You know what I'm saying? You shining for the hood, but they watching you and they want you off the streets. This is what's going on? What's going on, memory? This is Young Thug's preliminary hearing. Yeah, this is the preliminary hearing for Young Thug and Gunna. Yeah, we just tapping in. This is live, currently going on right now. It's streaming on YouTube, and I'm streaming it on my YouTube. And we talking about it.
I apologize, Your Honor. JF, for one last thing I would like to put on the record, and it's with all due respect to Mr. Gary and Ms. Rosenwasser, who I have the utmost respect for, but they have, for whatever reason, come up with a policy to
appreciate you tapping in, brother. Appreciate it. Thank you.
Defense counsel outside the courtroom. And
just talking about how they playing with these people's life.
So there's been that makes communication very difficult for us. I mean, we're happy to communicate with them. It's been their choice not to, and that's not just on the issue of resolving this. It's on anything involved in this case, and so the court needs to be aware of that. It's not a lack of defense counsel having effort to do so, and it's not. I'm not trying to disrespect them in saying that. I just want the court's bring it to the court's attention. I also think, given the history of the technology issues and the difficulty with having our clients know when the hearings are, having us know when the hearings are as defense lawyer, and having our clients be able to hear and see what's going on behalf of Mr. Kendrick, I would like to formally object based on his Sixth Amendment rights to him attending via Zoom at any future hearings or the trial, and request respectfully, humbly, that to this court that he be required under his Sixth Amendment right to be present in person in the courtroom for any hearings.
Okay, let me address a couple of things. I'll unpack a few things, Mr. Appley, you just said. In terms of the Sixth Amendment, I know your client, you and all the defense counsel, all defendants enjoy the Sixth Amendment right to confrontation and be present. I would remind you, Mr. App, as well as others, that we are still dealing with a global pandemic, coronavirus, COVID-19, and now its various variants. And for those reasons, we, in the interest of safety, have our Supreme Court has authorized this particular methodology. So I'll note your objection for the record. I'll note that, we're still undergoing a global pandemic. Right now, we're dealing with, in the public media about another booster shot that's soon to be available, and people that are still getting sick. The other issue becomes the transportation issue, the safety issue of the numerosity of various accused. I can tell you that I share that concern, and a little bit closer to us getting trials quicker matter. I can rest assured that your client will be brought over here for in-person proceedings and for trial. But at this point in time, given the issues that the court has to deal with in terms of getting logistical issues, I would say, let me phrase it that way. It is a challenge at this point in time. It's not lost on me. So I'll note your objection on those bases that you made for purposes of the record and for any future proceedings that may need to occur. But at this point in time, I'll deny them at this point. The motion will be denied at this point, but you can certainly raise it again. And but this is the best way that I can deal with the number of folks that I have present and the various issues that I have.
Now let me let y'all know this, cause they lying, right? Let me say this. Now, okay, the pandemic, yeah, whatever's been going on with that pandemic, safety concerns or whatever. I'm gonna tell you what's bigger than that. This is what they lying about, y'all. They're trying to keep from having to transport all of them folks to the courtroom. You know why? Because them little 10, 20, 15, 30 minutes that they'll be in behind the courtroom in a holding cell together. So what they want to do is keep these motherfuckers as separate as possible. They don't want them to collaborate no kind of way. They don't want them to have any time to talk about anything because they're using them against each other. So why the pandemic? Yeah, that's a problem. But hey, the excuse is what the real reason is they don't want them collaborating together. They want to keep them playing each other against each other. Also, and for the ones that are on the case and they're snitching, they're gonna get beat up. So if they bring all of them, they transport all of them folks and don't do it via Zoom, and they transport all of them to behind the scenes of the Fulton County courtroom, some snitches gonna get beat up. So that's the real reason why everybody is doing stuff via Zoom.
Yes, yeah, not Judge Glanville in particular, but the clerk's office will notice all future to everyone who has entered an appearance in this case. Okay?
And on the last, Judge, as far as the communication,
Let's deal with that, Mr.
we
Geary.
believe we have been misquoted. I didn't want to specifically bring that up. We'll deal with it in-house. We are communicating as we believe we need to move the case forward. We are limiting communication except in court, or if respectfully, if we feel we need to respond. There are counsel in court that ask specific questions, and we have responded to. So we're not communicating. We are limiting that communication to that which we think is essential.
Okay, all right. Counsels, I'll just reiterate that your duties as officers of the court. Please go ahead and continue to communicate with each other as you see fit, bearing in mind that, since the court now has made it very clear that any violations of, I will sign an order which will bind all of you to what has been proffered today in court of the concerns of the state, and I'm not afraid to deal with it, but I hope I don't have to, because all of you are professional advocates with a lot of experience, and this should not be an issue, but just to make sure that everyone gets a fair trial, a just trial, legal trial, it's necessary. So I'm probably telling the obvious to the group assembled, but it's just part of the rules of the road going forward. Okay. All right. All right, one more thing I need to deal with is this, and Ms. Rosenwasser, what say you about this sentence here about the after the 25th of November, 2022?
Your Honor, basically our position remains the same.
I know that, that hasn't changed, all right, but I'm gonna require that you start to, that any statements you have not otherwise provided already no later than September 23rd, September 23rd, with the confidential updates every 14 days thereafter.
Then, what's that?
We understand that statement, Judge.
Okay, all right. All right, the next sentence reads, the confidential information may not be shared beyond members of the defense legal teams. That's fairly, that would be, goes without saying. And it's fairly encompassed with some of the other things that you have, the requests that you have made globally. And then, but I think Mr. Steele has objected to the sentence after November 25th, 2022, the confidential information may be shared with the defendants while in the presence of a member of the defendant's legal teams, but the defendants are prohibited from retaining copies of the confidential information.
Judge, our concern has always been the safety of our witnesses. We would ask if the court's going to modify in 30 days that you stick with that. Once it's communicated with the defendants, if they have the desire to do so, that we communicate if they want to, and put that in danger. I understand the counsel say they'll steal, they're not going to do that. I believe them at their word. Once that's communicated outside of their team, it's out of our control.
And to this, it bears without saying, Mr. Gary, remind me something that kind of I need to raise. I know that all of you are really seasoned. I'm not ready to deal with Mr. Theory quite yet. So,
He might have time on this.
But thank you, Mr. Gary. I appreciate that.
30 years, man, but behind something that's legal in a lot of parts of the world, man. It's crazy. That's crazy. Behind keeping it real. Now he's sick. Hey, man. I hate to hear that, my brother. Look at Jeffrey Williams sitting in there.
Mr. Theory? Okay. Yes, sir. And I apologize for hijacking you.
Uh-oh, damn, I'm messing up the audio. I'm messing up every damn thing. Good grief. Let's get back into it, y'all. I'm messing up, y'all. Now we got to deal with a commercial. That shit cute. Skip you.
Yes, sir. And I apologize for hijacking you.
Oh, my boy Urban. My boy Urban, man. Look at my boy Big Ant, man. Y'all make sure y'all follow him on YouTube, man. Bro got some good content. He got some real good content out of H-Town. Uh-oh, that's not what I'm trying to be, though. Out of H-Town.
of my legal team
Yeah.
to be able to inform me as
If his show big as mine, I'll watch him.
Okay, one more thing.
But we both doing the same
Your
thing.
client's not on a platform. And there seems to be some issues, so I'll take whatever you want to say, but let me go ahead and wait till the end and bring him, let the jail team kind of bring him out, okay? So you can proffer whatever you need. And
I just wanted to stay on topic.
and he'll be present, so just park that just for a second, and as soon as I can go ahead and do that, I'll bring him out. We're gonna probably try and bring him out last, because, so that we can deal with some concerns the jail staff has, okay?
Yes, sir.
All right.
May I just say one thing on that last comment, please?
So I've got other things I gotta move on to. Make your statement, Herman, let's go.
Thank you.
I would ask you to consider Mr. Williams and separately about, I didn't adopt the November 25, 2002 date. Mr. Williams is in a jail outside of Fulton County. There are 0 cell phones in that jail. Every one of his communications outside of his legal team are recorded. The state can tell whether he's talking about a discovery. He has done nothing to my knowledge to obstruct or intimidate at all. And to bound me with the other people who want to not share with their client until November 25th, they can do whatever they want. But I have the biggest issues here. I am in all of these overt acts. I have all of these witnesses to deal with. And if I can't share this information with Mr. Williams, I lose 2.5 months of work because I can't share with him information, then that is just not appropriate. If I ask
You can't do that.
Other people, if Mr. Kitchens thinks that that's great for him, then I don't care what Mr. Kitchens wants to do. He doesn't have to share anything with his client. But I am not agreeing. I'd ask you to rework, at least for Mr. Williams, this November 25th date. I understand the state's concern, but it should not be with Mr. Williams because he does not
What
have
date do
cell
you
phone.
have in mind, mister? Do you want me to not put a date in here? Is that what you're asking me not to do?
I just want to share with Mr. Williams like we do everything. We go over all the discovery all the time, every day.
This is not the ordinary case, Mr.
You
Steele.
don't give a damn if it's an ordinary case or not. You got to follow the law.
To invoke the
Hey,
dictates
how
of
you doing?
1716-4 Delta. It's a pretty extreme remedy, and it's extreme because of the safety posture of this case. That is the only reason. And if it were not the case, then I would have no reason to do this. So I have to balance ordinarily your right to speak with your client freely, and I'm not in any way saying that that's not important, but I also have to balance the safety and interests of everyone else in this particular case. So that's why I'm gonna adopt that 2 paragraph. That's the only reason and that's why I'm gonna adopt the date. So, that's the reason for the adoption of that particular paragraph.
I would just ask you to look at Mr. Williams individually because he's in a different jail. There's never a cell phone. 0. There is not a cell phone in the Cobb County Jail. He is in isolation by himself. His cell was just searched yesterday. So I'd ask you to please, for Mr. Williams. And he's also the biggest person. I heard Mr. Kitchen's counsel say there's no witnesses. One witness who's exculpatory to him. We are going to be involved in this case from every witness so far. And I need Mr. Williams' help.
All right, sir.
Thank you. And I don't think the state carried their burden to show that Mr. Williams did anything untoward towards any witness. I understand that there's a concern. I share that concern. I don't want anybody to get hurt. But I could share this with Mr. Williams within the confines that the court has ordered him, or the sheriffs, I guess, have ordered him to be housed without him giving out this information. I don't believe he would do it anyway, but there are ways to check to see what he's talking about. So I would ask to be allowed to share with him at all times. And I feel very strong. I wouldn't take your time. I feel very strong.
I understand that, sir. I understand that. Yes, Mr. Geary. What were you going to say, sir?
What purports to be an Instagram post from Mr. Williams last weekend, which would have been from the Cobb County Jail, can't ascertain that I saw him do it. But there was an Instagram post.
Hold on one second. I think somebody's talking at this point.
I don't know if somebody else controls Mr. Williams' Instagram account. I mean, because he obviously probably does not have a phone in jail. So,
Communications is going to have. I don't know Mr. Williams directed that, but it appears to be on his Instagram account. I would believe that something, which is still a concern if something is conveyed.
and this is part of the conversation why I had with all of you about, your teams and everybody else. You really got to zealously clamp down on, it's like dealing with classified information. It's like, it's need to know at this point in time. And if people don't need to know it, you don't need to disclose it. And it's going to get somebody either hurt or somebody in a lot of trouble. So that's why I would just say, Mr. Steele, you well articulated your point. I'm going to leave it as is right now. I understand.
Well, I'll ask you to reconsider in the future because.
Yes, sir. I understand that.
Handcuffed me. And that last tweet that was sent out to Michael Phelps is recorded. It's been investigated by the sheriff of that county. And it was a conversation that's recorded between Mr. Williams and a member of his close friendships, that he asked the other person who has control of his Twitter account to send out that, or the Instagram maybe. That is not a reason to.
Well, this is part of the conversation, Mr. Steele, and you and others are going to need to have with your clients, because this is part of the state's concern. I mean,
that was innocent. That's nothing bad. Asking somebody to tweet to Michael Phelps, can you swim 100 miles in the ocean? That has nothing to do with intimidation. If I ask you,
well, if I can communicate through a family member or somebody else, then I can communicate something else.
it's recorded.
So?
It would be found out immediately. That is a crime. Witness intimidation is a crime. It can be used in front of the jury's consciousness of guilt. That's not going to happen. There's no evidence it did happen.
Well, let's send the abundance of caution right now, and we'll leave it. I may change my mind at some point in time in the future, Mr. Steele, but not now. Okay? All right. Okay. Thank you, sir.
Your Honor, this is Steve Sato. May I respond for 2 seconds to the suggestion about prosecution and defense not communicating outside of court? I just want to bring one matter to the court's attention real quick, if I might.
Yes, sir.
If we send a specific question in writing to the prosecutors, I'm hoping that they will reconsider and at least respond directly to the question. The alternative to that is to file some type of motion with the court, which would, under normal circumstances, never need to be filed. For example, I listened to something in discovery was a dropout. I've asked a specific question whether this was an actual dropout or in some formal fashion there was a redaction. That was the question asked. If I can't get an answer to that simple question, then I have to file a motion with the court in order to get that response from the state. That seems to me to be a total waste, not of my time, not of the state's time, but of your Honor's time. And we're trying to avoid that. So maybe the state could reconsider oral communications, one thing, verbal communications, same thing. But if it's in writing, maybe they could reconsider their position and respond so we don't tie the court up in matters that it doesn't need to be involved in.
Okay. All right. Look, you all just communicate with each other. I mean, I understand you all have an information kind of choke point given the equities that are involved, but I think all of you are still subject to very, very hefty penalties if this stuff goes sideways. So please consider the normal routines of communication. And for those of you that I mentioned earlier, all of you, I should say, just be mindful of confidentiality and communication. It's still very, very important, and it would resolve and probably everyone would better be served by it, so that you can continue to pursue discovery and get what you need.
Yeah, man. I can't see it either, bro. I don't know how, why, you know what I'm saying? But all I could do is say, when I was out there in the streets, I didn't know the law. I didn't know that it carried a whole bunch of prison time. But obviously now with today's, with today's going on and social media and, these phones and everything, how could you not know that everything that you do carry a whole lot of time, man? It's crazy, bro.
And we get out of court today, either today or tomorrow morning.
All right, that's fine. Okay. All right. Mr. Seminoff? Sir.
Good. I just wanted to alert the board that interview three defendants, that the board instructed me to interview. They all qualify on submit the C3 paperwork.
Okay, so again, that's Mr. Fleetwood, in position number 7.
Mr. Blaylock and Mr. Nichols.
Mr. Nichols is in number 9.
And Blaylock is 15.
Blaylock is position number 15. Okay, so.
Your Honor, I do want to alert the board that Mr. Fleetwood informed me that even though I completed the interview, he does wish to hire a private attorney for attorney purposes at this time. However, but the board can reference the anyway.
Mr. Fleetwood? Where is he? Let's see. Have they been?
Yes.
All right, Mr. Fleetwood, what I'm going to do is I am going to have Mr. Seminoff start the process to qualify you. And if you have an attorney if you hire private counsel by the 5th of October, that private counsel can go ahead and substitute in, okay?
Okay.
But I'm going to go ahead and instruct him to start the process at this point, okay?
All right.
All right. Sir, you are welcome to remain here, and you're welcome to excuse yourself, sir, okay?
All right.
All right, thank you. Let's see what else. So, that's number 7. Okay.
And then number 4, I believe, also requested C3 counsel. I didn't get to them, but I was on that paper. State, regardless of the application, once the practice is
Okay, sir. All right. Wonderful. Unless you have any other business before me, sir, yes, you may be excused at this point in time.
Thank you.
Okay, all right. Yes, sir. Okay, councils, it has been a minute since we have taken a break. We have not had one all morning, and I know we still have
Ain't this some shit? So they just finna take a break, and that's just it. Yeah, that's just it. The end. They about to take a break. And that's it. They about to take a break. What kind of man? Boy, I tell you, these folk play with your life, boy. They play with your life. They play with your life. They do what they want to do. Let me see. And that's just it. Let's check out my boy Urban Politicians. Urban Politicians TV, man.
Spray on chrome technology. It's here.
That boy out of H-Town, man.
Choose any color.
Yeah, I'm too cheap to get the damn ad-free YouTube. So what? So what? Okay, well, so much for that. I got to, let me see how you turn this camera around. Uh-oh. How you turn this camera around? Turn this camera. Boom. All right, there we go. Yeah, I'm new to the YouTube scene. Yeah, I'm new to the YouTube scene, so I ain't got this StreamYard stuff put together. Yeah. It's my first time streaming the StreamYard. It's pretty dope. I gotta cut this camera off for security purposes at the moment. Yeah. Cause I hate to have to discipline somebody. Yeah, but just to finish out, man. I appreciate everybody that's tapping in with the channel, man. I appreciate it. All my channel is geared to doing is trying to keep people from going down that road, or at least give you something to think about while you out there committing them crimes. Because these people not playing with you. They just not. They not playing with you. They want your life. They want you off the street. They want your money. They want it all. But they cannot give it to you. They cannot take it unless you give it to them. So with that being said, man, I appreciate y'all tapping into the live stream, man. It is much appreciated. More to come, bigger stories to come, bigger conversations to be had. Subscribe to my channel, share my YouTube videos. Hey, man, I like I said, I tell people all the time, I'm a former convicted felon. I lived the street life. I never was in a gang. Don't profess to ever be the baddest motherfucker on the street, but I held my own through 16 years in prison. That's what I did do. I didn't go out bad. I wasn't punked. I wasn't pushed around. I won a lot of fights. I lost a couple of fights. You know what I'm saying? I lost a couple of fights. It ain't no big deal, but guess what? I survived through the whole thing. I came out, um, made a business, lost my business, got a pardon, uh, have served in the community uh, in numerous ways. And this is my way of paying everything forward is to try to get young brothers to think about what they're doing before they make dumb decisions. So I appreciate any type of support to the channel, man. It is greatly appreciated. I appreciate everybody that follow me, man. So we'll be tapping in for more. But I appreciate y'all, man, and I'm out. Till next time.